So we are business lawyers with focus on strategy, meaning that we aim to provide relevant, business relevant advice, not to talk about checklists or what the law says or what you should do, because we all know that we should do a lot, but is it relevant? And I don't handicap my clients in order to insist that you have to be best in class, because usually you don't earn as much money. We, though, being in fintech, which many of us are, it's a life and death question to some extent. Or if you take money and you either are a loyalty platform, or in PSD2 you're another actor that can facilitate transfers or initiate money transfers, then either if you do a more serious breach or don't disregard, or do disregard the GDPR integrity aspect and the security aspect, then both your customers and your permits may shortly be gone. And we see that happen. So, good morning and welcome to this presentation. It's quite early, but I will be as brief as possible. So this is actually a fact that you are already late. It's just to feel that, to own that you are already late. It depends obviously what business you are in, the size of your organization, the maturity, your competences. But in short, you are late, and you will not be able, if you're being a mid-sized or large company, to be as compliant as your risk managers would love to be. But needless to say, next issue is that how can we prioritize that? My clients fall into two big categories. Either they are eager to learn and see the new opportunities when data is actually defined. You could more easily present your customer promises, what you actually deliver. But on the other hand are the most often the digitally immature, not the native persons. Perhaps it's a generation issue, I'm not sure. But the other group is that all the other in my CEO networks, they are not doing this, and they are in digital advertising, they are in institutions, financial. So what should we do that? Well, that depends on how you view your customers, and do you still believe that your customers are solid, or are you working in a liquid market? Do you deserve the trust? And having worked at big companies early in my career, I've seen how quickly the landscape can change. I worked with Nokia in 2006 when they had 60% of the smartphone market. Only 2 years later, they were down to 40. And we all know that they have just recently started to do dumb phones again. So we should all be very humble towards how we read market trends and consumer. And what we also see that it's also a maturity in the US, as it is with comes to digital innovation, IT services. The US leads. So we have fresh data from late 2016 that on average 77% of US companies, they have a budget of $1 million US or more, just to do the gap analysis, to change perspectives, evaluate their IT tools and vendors. So that's quite a serious commitment. And as we all know, the General Data Protection Regulation, which we talk about, GDPR, it will come to full effect 25th of May, and there will be no grace period. It will affect all operations, all contracts, irrespectively of when you entered into a contract. And it will concern personal data in the broad sense for you EU nationals, irrespectively if you are a company based outside of the EU. I usually say use this variant of this quote, and this is actually where the problem starts, because we will talk later. We will be hearing from industry leaders, cloud suppliers, ISPs, and data center providers. And they have obviously fantastic tools, solutions, processes to onboard you. But that's not enough, because business or our organizations are made up of people. And we have to change the culture and awarenesses. GDPR, if you are going to be enough compliant, it really depends on that you work in processes that are adapted to the GDPR, but also to your organization. So I cannot write or draft contracts that are compliant if they are not actually grounded in how your company is organized or how you work. Yep. So we all heard that the GDPR is a significant raise in demands from the directive that's applicable now, PUL in Swedish short. And I will just briefly go into them. So we have a completely new principle, the principle of accountability. And it's actually shifted that today the modus operandi is that all organizations in certain aspect has to inform the data protection office that they are doing certain kinds of processing as a main aspect. But if you have a ombud, then you are free, because the ombud is responsible person for that processing, in short. But come GDPR, all companies, meaning also the suppliers that are data processors, have to show compliance, meaning that there are a mandatory document file or processes that all companies need to have and should at all times be able to produce for inspection, and that will raise some new concerns. We have another aspect that's really have business implications for this industry, or for IT suppliers as such, is that they will be introducing the concept of joint liability, meaning that if you are in a value chain of the customer's users, the individuals, and yourself, or you have a sub-supplier, then an individual or the authority may actually direct claims to either one in the chain. And this is only if you are poor in describing the roles and responsibilities. Most often, as we all know, the supplier of the service is the most knowledgeable of the service features, of the security measures, of the evaluation. And the purchaser often only rely on the information given and don't articulate any demands. In the GDPR sense, then the supplier would be the responsible party, having the actual right to decide the purpose and the technical aspects. So this is very important. It affects how we draft agreements, how we evaluate our subcontractors, or from a customer's perspective, a purchaser, how you evaluate the subcontractors. Transparency is an old but yet a new concept. The GDPR also stresses the fact that you have to, in each aspect, inform prior to processing of all aspects of what you are doing. Why do you need this particular information? What's the purpose? And no, you will not be able to package many purposes. I also often see that in order to accept this service, you also have to accept to receive direct communications or marketing, or either that sub-suppliers do big data or analytics of the individual's data. And if you have any kind of analytics that are not based on anonymous data, then you should rethink. Rectification and erasure, and this is more of a new concept. It's really that at all times and free of cost, an individual can request to have a full complete list of all the information, where it's stored, for how long, to have a draft, to have a register. And also the individual can ask for, request rectification if the data is incorrect or if it's too old. Erasure. And erasure is not a obligatory right. The company having this data, they are free to decide in which extent should we erase. Are there any local laws, documentation to protect your own legal rights that could justify that you actually hold on to that data for some time more? And also novelty. An individual can object to automated processing or the use of analytics or algorithms that may discriminate that person. So if you use machine learning, AI, etc., or automated processing, that has to be informed, clearly spelled out, and the reasoning behind the actual decision-making of an automated tool needs to be explained in terms of conditions or in the sales contract. And before certain high-risk endeavors or processing of personal data, you should typically international transfers or use of automated means, you have to, as an obligatory, perform a data protection impact assessment, konsekvensanalys in Swedish. And the one that we've heard sometime, data protection officer for certain companies who process personal data as a key activity, and the fintech is in this category, they must appoint a DPO, because the DPO will act as the mediator sort of between the authorities, the individuals, and the company, and is responsible to lead the culture of compliance within the companies. And that could be external or internal solution. If you're considering an internal solution, then you must be aware that you can't have a conflict of interest. So any person that is in a management position or lower management in IT, law, etc., will have a conflict of interest and will not be able to have the former role of the DPO. And the last principle is data minimization. You should always ask yourself before processing, could you do without this particular data? Could you do it on an automated or an anonymous data? There are architecture requirements of privacy by design and privacy by default. That is very important. How you construct and how you evaluate new services. And going back to the two typical customers, the one that points at his competition and says that they are even worse than I am, so why should I change? Well, I think the answer is, what would you trust, truly? The most important thing is the goodwill or the transparency. How do you view your customers or potential business partners? And I see for the company that are more negligent, we could say, towards how they process data, they will at first be turned down from new business because their customers or business-to-business customers, they will have to do a data impact, the data protection impact assessment. Then they will find that, oh, this is high risk, and they don't have an actionable plan. Or if you have VCs investing, then it will be marked up as a high risk, and your valuation will be heavily discounted. If you have a kortinlösenavtal, meaning an agreement with the banks to process money, then they will reevaluate that. And your normal insurances doesn't apply because it's a force majeure if if you lose data or misplace it. And the fines, we could just mention them. It's the higher of 4 million euros or 4% of the global turnover of the ultimate mother company. So that's quite heavy. For minor offenses, such as not appointing a DPO or doing that wrongly, then it's 2% of the turnover and 2 million euros. And that's per incident. It's not a capped fee. It could be aggravated. Although we will see, but we see that in other countries in the EU that has a legislation that's more similar or more close to the GDPR, such as Germany, France, UK, they are being fined quite heavily for not having to share the data within the companies, within the own organization, between countries, or if you share data with the US company that are not under the privacy shield, etc., then there are fines to, million euros or such. So don't forget the customers. Then the business impact. There's just a few issues, of course. You have to evaluate your customer promises, because why do you want to communicate or use data? Often the answer is to give better services or provide more services. And if you use this smartly, then you can actually package more features into value propositions. So instead of asking for a blanket consent to use data for 20 different reasons, if those reasons are valid, then you will have to offer or ask for consent like 20, but perhaps 15 times. So doing it smartly, you will have to demonstrate or show that you are doing all of these services, not big thing. Then we have IT procurement is also business impact, because I have seen over the last year that the big procurers privately, they are asking for warranties with fines. So the supplier can show or demonstrate that they have already taken certain actions, that they are or will be that they are complying with PUL today, and that they will be compliant with the GDPR next year. And they are turning down customers. And also when it comes to infrastructure services, we also see that the prices that certain companies will receive will depend on, to a certain extent, which if they are a high-risk client. So that's quite interesting. Business impact will also be that you have to improve internal processes. Compliance is a culture, it's often said in these privacy circles. But still, the DPO will be a key figure. We also see when we are doing these gap analysis, which are the first step, truly, we, together with the customer, discovers, it's obvious for the IT department sometimes, or it's obvious for the marketing department, we discover new sets of data. Or, oh, did we have this kind of data? How can we turn action on this? How can it be actionable insights? And then we are a partner to construct offerings or new services. So I think it's a very good, if you do the gap analysis right, then you can actually learn more of what you actually deliver and sell more, which is a good thing. And obviously, in outsourcing or when you have several partners, you will have to take into consideration that your vendor management has to change. And I haven't seen any contract that will not be changed, because you have to manage the awareness and the compliance towards IT security and integrity in your chain. Otherwise, we have that notion of joint responsibility, liability. So how to get started? It's quite easy. Don't do a too big project. Don't be too ambitious. It's like the New Year's resolutions. You have to be quite humble and do it step by step. Otherwise, you will have a big splash, and the prestige within your organization will be hindersome. So don't be too ambitious getting started. So this is also depending on your risk level. We are doing these kind of gap analysis and GDPR work from like 50,000 Swedish kronor to millions. It really depends on the actual customer, how risk aware, how much of a trust, how do they value the trust for the companies. So we always start out with a gap analysis, going through the business critical organization parts and how the IT environment, the customer promises, the organization. And then we do a GDPR mandatory file, which has evolved through legislative work, especially from the French SNIL, the French authority. They are very active, and they, I guess, have a bigger budget than the Swedish authority, because they are advising more, giving more concrete examples. So in the mandatory file that all customers or companies have to have in order to fulfill the obligation of transparency and accountability, there are certain documents regarding the internal information and processes, IT security policy, the process of giving access to different data sets or systems and evaluating that. That is very critical and has been very criticized from the Swedish authority when it comes to healthcare. That they just, if you are newly employed, then you get full access. That's obviously a simplification, but that has certainly been the case. Then we have external information and processes, and that's how you do a subject access request. You have to do it very hastily, within 30 days. Otherwise, you have to engage and give the reason why you can't give out all the information. And also, obviously, on your web pages or apps, what type of information do you collect, why, and are there any automation tools involved? And ask for the right consent. Or could you repackage that and do it as a service and rely on the contract? There are perhaps no need to ask for a consent, because a consent isn't that good to have as the main legal ground, since it's revocable at any time, and then you have to delete the data. Then we have agreements with third parties, that's your suppliers, customers, etc. Also regarding international transfer. So this is really end of my talk. Yes?